Welcome back. Well, the Bhisho High Court has today ruled that the Special Investigating Unit must stop its probe into whether the Eastern Cape Premier, Oscar Mabuyane, is guilty of academic fraud after he submitted a proposal for a master's thesis at the University of Fort Hare. This all started when President Cyril Ramaphosa issued a proclamation for the SIU to investigate corruption at the university. They then started investigating whether Mabuyane benefited from a professor now known to have been involved in selling degrees. Mabuyane said the SIU was going too far in investigating him. He says they wanted to search his home before just asking him for certain emails and other information. Mpumelelo Zikalala is an attorney and a legal expert. Mpumelelo, good afternoon to you. This is actually a case with quite big implications. Firstly, why did the court find that Mabuyane has a case here? Why did it rule in his favour?
Well, the court looked at the actual proclamation and said, you know, when the SIU was given, let's call it a shopping list of what is it that you must look for the president, it did not include master's degrees, only limited itself into honours degrees. That was the first one. So in terms of the ambits in which the investigation is supposed to take place, looking for anything further than that was then saying you are acting beyond your scope and the power that you've been given. Hence, you can't go over and above that particular fact, which is, in my humblest opinion, the narrow interpretation of what the proclamation actually states. Remember, before we get there, before the actual case started, there was an amendment of what Mr. Mabuyane was now looking for. Remember, when he started, he stated that the president has no powers to issue such a proclamation at a later stage. He backtracked and then said, yes, President, you may have powers to do so, but I want to concentrate on the extended powers, or in the ultra-virus action which has been taken by the SIU, in which it was then accepted. If we then look at the judgment in depth, we're then able to see that even the elected representatives which representing the president were then excused at a later stage because there was nothing the president was supposed to answer to. So the case, or part A of this particular matter, only dealt with the powers of the SIU, in which the courts were of the opinion of saying that, you know, the shopping list that you were given, you've gone beyond the shopping list. You can't continue with that evidence up until part B. We will look into the in-depth interpretation of what the proclamation means, has been ventilated and argued before the court, and a decision only comes then, and then you can be able to understand whether you're able to continue with the investigation fully, or you are stopped in your tracks and can only deal with information that has been provided to you.
Mpumelelo, I mean, I'm not a lawyer, and I realize the law is important and the words matter. But it seems a bit ridiculous to me, if I may say, and I don't mean to question a judge, although sometimes I have, but it seems a bit ridiculous to say you can investigate corruption but not academic fraud, or you can investigate academic fraud but only for honours degrees and not master's degrees. It's like saying you can charge someone for the robbery but not for the murder.
Which is why I say it's more of a narrow interpretation of saying, look at the shopping list that you've been given. You can't go beyond with the listed items which are there. But something which, to me, which I seem to align with what you are saying, if you then look at the proclamation, the last words, it then says on it, anything which has to do with maladministration that has taken place of anyone must then be considered. So if anyone has conducted themselves in an improper manner, then it basically says us as law enforcement agencies will have power to investigate that particular factor. So it's on that basis in which, with my humblest opinion, I would seek to differ with what the judge has said in terms of the powers that have been provided. And you look at the bigger context of the reasons why the SIU has been created, even the proclamations why they are there, and if they're able to find any things which have not gone well, which are against the law, it must be within their powers to then come back and say, we cannot have anticipated all the maladministration or the crimes that could have been broken in that particular institution. So if we have a general interpretation of what has been done, and the test which must be passed saying that, is this against the law? If the answer is yes, then you are going to punish you, regardless of the individual that is there. Then is what I thought the court would have looked at, rather than saying that you are going to adopt a narrow interpretation. The powers of the SIU are only limited to what the proclamation actually says. The proclamation is limiting itself to honours degree and not master's degree, and that's where it's going to end. You are quite right in saying that the rationality of it seems to be a bit far-fetched.
There's another issue to it, which is that if Mabuyane has nothing to hide, I would expect, and his spokesperson, Zuko Goodlimpie, did say, I think 6 weeks ago, he did say that Mabuyane would comply with the investigation. He would help the investigators. Now, I'm presuming that most of his communication with the professor who we now know was involved in academic fraud, or Fort Hare says he was, the university says he was, that he would hand those emails over. Instead, he seems to be opposing it. Now, if the SIU wanted to raid his house and didn't ask him for the emails, well, the SIU might well be guilty of overreach there. But to challenge it in court?
I think it's one of those, I would say it's a futile attempt from my side, because even in the judgment, the judge is very clear in terms of saying it does not mean that the university cannot conduct its own investigation when something has gone wrong, if they suspect that there's maladministration or that degrees or qualifications were being bought. So in that case, it's a lack of a better word, a shallow win for me, because it does not take away the cause of concern that I have as the applicant. It simply says I'm cleared in this part of the investigation, and if anything further goes beyond that, then tomorrow morning, there could be an application or an investigation which then takes place, looking into how those master's and doctorate degrees were given, so that we're able to see whether they comply with the law or not. And you then come back in terms of saying, let's understand it from the side of Mr. Mabuyane, saying, if you are going to accuse me of something, then take me into a platform or a forum in which I'll be able to represent myself, and all the stakes must be, or the ground must be level. So after this investigation, then I'll be able to comply with whatever that you are looking for. But you must know that I'm willing to defend myself as I'm pronouncing my innocence now. So the mere pronouncement of my innocence does not mean that I'm giving you free range to look at the documents that I might have, or that I might use at a later stage to defend myself. I think that's where it was coming from. But still, when it comes to this proclamation and what it was intending, let's look at the intention of it and what they envisioned at the time they drafted it and what they've got on the ground. I do not think that the narrow interpretation ought to have been provided, because you don't know as you are writing this proclamation as to what's going to happen. It's a different story when you're writing a charge sheet, because you've done the investigation is done and dusted. In this case, you don't know what you're looking for, but you do have a hint of saying if there's something wrong which is happening within that institution, I can send the SIU, which are more specialized in terms of doing the investigations, to go there and investigate. So if they come up with something which was not included in their shopping list, they shouldn't be punished in it, unless if they do something which is contrary to what our constitution says. The manual investigation has been done in a way which is not in line with our constitutional values and even the protection of the Bill of Rights, then I would understand. But to simply say, because you do not include the word master's or doctorate degrees, we're not going to investigate that. It seems to me, a narrow interpretation which does not seek to fulfill the intention of the proclamation itself.
I think you and I have both been very polite about our views on this, but I think they're pretty clear in Mpumelelo. As far as I can remember, is this the first time that an SIU proclamation has ever been struck down? I think it may be. I mean, this sort of opens the door for other people being investigated by the SIU to have a go at the proclamation.
Definitely, and even any other specialized law enforcement agency to then say, let us look at the powers that be, even as a commission, for example, to say, look at what the commission was set out for, and in terms of reference, let's apply another interpretation of what is written in the shopping list. As I stated earlier, you don't know what you're going to find out, hence why you're conducting an investigation in this particular manner. So if you're going to punish someone for limiting it into this particular, in these factors, then you're basically saying, investigate what you need to find. Even if you find maladministration that has taken place within your junior degrees, then you can't go and execute or punish those individuals that have unlawfully benefited from those proceedings. Something which I don't think it's in line with what even the principles in which are being sought to be protected, the constitutional principles which have been sought to be protected by our courts. I don't think an order in that particular matter would be successful.
Mpumelelo Zikalala, legal expert and attorney, thank you very much indeed. It's a fascinating case. I'm sure there'll be a lot more commentary around it. To update